here with Adrian Berry and Gordon Lee. I'm Sonali Naik, Garden Court Chambers, as you know. Thank you very much for joining us. Remind you that this free webinar is brought to you by Garden Court Chambers Immigration Team, obviously the top-ranked immigration set. We'll be covering the implications of the three recent Court of Appeal cases of Chowdhury, Kolikai and Dachi, together with the recent upper tribunal case of Latchi, all of which concern the role of the courts and the tribunals in cases where the Secretary of State has made a decision to deprive an individual of British nationality. The first person to speak I'd like to introduce is Gordon Lee. He also acted in the case of Latchi, who's a regular hearer in the High Court and Court of Appeal, in immigration and asylum, has been in the Supreme Court in various leading cases. He has particular interest and expertise in judicial review and unlawful detention, as well as nationality. So thank you very much. I'm going to hand over to Gordon.
Thanks very much, Sonali. I'm going to deal with the case of Kolikai in the Court of Appeal and also deal with the case of Latchi, which I was in the upper tribunal. Kolikai is an interesting case in many respects. It's something of a window into the Secretary of State's decision-making process and some of the chaos that appears to be going on behind the scenes when different approaches and different policies kind of grow up organically as a reaction to different circumstances. It reached the Court of Appeal after the appellant, Mr. Kolikai, won in the upper tribunal on one ground, and the Secretary of State appealed on one ground, and the respondent, as he was, Mr. Kolikai, cross-appealed on two others. So there were three issues before the court, which I'll come on to in a moment. But I'll just give you the facts of Kolikai for those of you who are not aware of it. Can I have the next slide, please? So he was a dual Albanian UK national, came to the UK in 2005, became British in 2009. By the time of the deprivation decision, he was married with 4 British children. In 2018, he pleaded guilty to 1 count of a money laundering offence. The facts of which, okay, so the facts of the case, Ms. Kolikai was a dual Albanian UK national, arrived here in 2005, naturalised British in 2009, and by the time of the decision, he was married with 4 British children. He pleaded guilty in 2018 to 1 offence.
We're going to jump on to looking at deprivation of British citizenship on grounds of fraud and the test on appeal after the recent Court of Appeal case of Chowdhury, which is one of the 3 cases handed down at the beginning of this year. I could have the next slide, please. So this is a very interesting case because the question of how the Secretary of State approaches fraud in the context of making a deprivation decision and the role of the first-tier tribunal thereafter in considering an appeal against fraud is caught up in the whole debate as to how the right of appeal against deprivation of citizenship, which you find in Section 40A of the British Nationality Act, should be approached. And you would think that something that had been enacted in the 1981 British Nationality Act and which had been in force in a variety of iterations, but largely as the right of appeal since 1983 in a fairly consistent way would be pretty straightforward. But there is in fact, there has been some doubt as to the correct approach. And indeed, as we'll see when we look at this case, there's been considerable shifts in the Secretary of State's own position in relation to things. And so the first thing to note really is that there's a right of appeal to the tribunal where a deprivation decision is made on grounds of fraud. And in making, in other words, where the citizenship was obtained by fraud, false representation, or concealment of a material fact. And in such situations where the Secretary of State is satisfied that that's the case, then she has discretion to go on to decide to make a deprivation decision and deprive a person of citizenship. And then, of course, the whole process is wrapped around with. Thank you very much. In this case, in Chowdhury, the Court of Appeal settles the issue. And what we find, in fact, is that it has the tribunal, the first tier tribunal, has a pool of fact-finding jurisdiction within which it can consider the question of whether there has been fraud, but that nonetheless other aspects of the test remain reviewable in the tribunal on traditional public law grounds. And as we'll see, there's a bit in the middle, a tiny little bit in the middle, which looks as if it could be more relevant in previous cases, and is also to be looked at on public law grounds, but that issue might have gone the other way and might also have been put into the pool of fact-finding. So the key things to bear in mind at the outset is that the fraud may be subject to fact-finding, the discretion to a fact-finding appeal on the merits, the discretion as to whether to proceed to deprive may only be reviewable on judicial review principles, but there's a tiny little bit in the middle which remains contested, and we'll see which way the Court of Appeal jumped in this case. So you'll see that in the way that this case progressed is that the first tier tribunal allowed Mr. Chowdhury's appeal against citizenship deprivation, but applying a Wednesbury test, the public law test as to irrationality, to the task of whether or not the Secretary of State's decision was vitiated by irrationality when considering whether the deprivation decision was exercised correctly. It found that the Secretary of State had failed to discharge the burden of proof resting on her to establish fraud, and that the standard of proof there was the balance of probabilities. Importantly, for the way the case was disposed of, it didn't make a decision on the human rights considerations. And if we can turn to the next slide, please. So the Secretary of State appealed, because the Secretary of State had come second to the upper tribunal, contending, among other things, that the first tier tribunal had impermissibly considered the issue of fraud for itself when referring to the burden of proof, and applying the approach of in the upper tribunal, the tribunal itself applied its own judgment of Cherry, and considered that the question of fraud is a condition precedent to the exercise of the power to deprive someone of citizenship, but that it can be reviewed and tested only on appeal on public law principles, so applying the Wednesbury test that we mentioned a moment ago. And if we go to the next slide, please. And then, so the tribunal, the upper tribunal that is, went on to remake the decision following the approach in Chimmy. And that was a case not on fraud grounds, but on deprivation, where it was considered of citizenship, where it was considered conducive to the public good, and where it was held that the only evidence that was to be considered on appeal was that before the Secretary of State, when considering the public law question of whether there had been error. But obviously, on human rights questions about whether it was compatible with Article 8, then other evidence might be admitted for consideration of striking the balance as to whether or not the decision was proportionate in the result. And so if we can turn to the next slide, please, we'll see the beginnings, the foreshadowing of how things ended up in the Court of Appeal. For the upper tribunal, the correct approach was a public law review only of all the issues arising for determination. And therein it was held that the Secretary of State's decision was lawful, and the upper tribunal itself also considered that there was no infringement of Article 8, that the decision on deprivation of citizenship was compatible with Article 8. So Mr. Chowdhury this time, rather than the Secretary of State, was the one to appeal, and he appealed to the Court of Appeal on the basis that the first tier tribunal, not the upper tribunal, had in fact applied the correct test to the question of fraud. That it was not merely a public law review, this question of whether the fraud had been established, but involved a fact-finding exercise on the fraud issue. And that was the basis of his stance. And then if we come on to the next slide, please, we will see what happened then. The Secretary of State at this point changed her mind in a welcome way. Often it goes the other way for us. But on this occasion, she changed her stance on how fraud was to be considered on appeal, and concluded that the correct approach to looking at deprivation decisions on grounds of fraud required a three-stage approach. Whether, firstly, in the first instance, as a matter of past fact, there has been fraud, false representation, or concealment of a material fact. On that issue, the tribunal has a fact-finding function. And that's the Secretary of State's new position in the Court of Appeal, having looked at the situation. And we'll come on to see how she gets to that point in a moment. The second stance of the Secretary of State, and this is the little sandwich bit I was referring to earlier, was that if such fraud is established, whether the citizenship was obtained by means of that fraud. So on the question of fraud, there's a fact-finding role for the tribunal on appeal, but the Secretary of State's stance was on whether the citizenship was obtained by means of fraud. It's the Secretary of State herself who needs to be satisfied as to that matter, and therefore her conclusion in that respect is subject to challenge on public law grounds only, so Wednesbury and so on. And then a final question, whether the discretion to deprive should be exercised. The Secretary of State's decision is reviewable on appeal only on public law grounds, so on Wednesbury grounds. So the great innovation, look at the shift in the Secretary of State's stance, is the first question that you can see there on the slide. The slight kind of caveating of it in terms of trying to claw something back from that approach is the little sandwich bit in the middle at number 2 there, and then something reasonably orthodox you'll see at point 3 in terms of how the approach onto the exercise of discretion. And then, so if we can turn to the next slide, please, you can see how Mr. Chowdhury viewed all of this. He agreed with point 1 that there should be a fact-finding role for the tribunal. That, of course, was his stance all the way along, and he didn't challenge the exercise of discretion being subject to a judicial review public law type approach, but he continued to challenge the correctness of the Secretary of State's stance on the second proposition that whether the citizenship was obtained by means of fraud was only to be challenged on Wednesbury grounds. So how did the Secretary of State get to this position? After all, her shift come from a moment of internal reflection. And her stance arose, and her altered stance arose on her own averment on her consideration of the case of Begum against the Special Immigration Appeals Commission and the Supreme Court, and particularly the judgment of Lord Reed, as you can see there at paragraphs 68 and 69, where he had contemplated and considering an appeal that had been diverted into the Special Immigration Appeals Commission, that different principles might apply depending on the nature of the decision under appeal, and that therefore that the first tier tribunal, this is now the Secretary of State's thinking, should decide for itself on the factual question of fraud or false representation, and so on. So there was sufficient flexibility in the framing of the approach to be taken to the ground of appeal as it arises under the British Nationality Act in section 40A, for on a fraud question, so not on a question of deprivation because it's conducive to the public good, but whether citizenship, in circumstances where it's considered citizenship had been obtained by fraud, for a different approach to one that might otherwise be taken in conducive to the public good cases. There was enough wriggle room that there wasn't any binding authority from Begum to condition this consideration of this fraud context. And so if we can have a look at the next slide, please. So what did the Court of Appeal think? Well, the Court of Appeal wasn't satisfied. Just because the parties agree doesn't mean the court has to follow them. They might be wrong still. The court has to be satisfied for itself. So of course there was a common stance now between the parties that fraud, the upper tribunal, the tribunal, the first tier tribunal on appeal could look at the matter for itself and find as a fact whether there had been fraud. But the court rightly observed that it needed to decide the matter to its own satisfaction, and then so Lord Justice Dingemans, in giving the principal judgment for the court, went to examine the matter for himself. And essentially, having toured through the case of the parties and having examined the matter for himself, he then came to the same conclusion, that it was for the first tier tribunal to find for itself whether the fraud was established, and that this was a statutory precondition for the exercise of the power to deprive. But his thinking, his reasoning is interesting when you look at the judgment, because of course he goes back to the question of how the particular way in which the structure of the power to deprive, as it appears in Section 40 of the British Nationality Act, as it relates to the appellate jurisdiction in Section 40A of the same Act. And then he also looked at more general principles when you've got an appeal, such as Section 40A against deprivation of citizenship, but it doesn't say too much. It's taken quite briskly in the British Nationality Act. Are there certain inherent aspects of the constitutional relationship and competency between the courts that allows the tribunals to intervene? And on this particular case, he was moved by the fact that the first tier tribunal has institutional competence in terms of its skill set to consider the question of fraud for itself, and it's certainly well suited, having the flexibility in its procedure and the procedural rules to accommodate the question of a fact-finding exercise. Self-evidently, it's the first tier tribunal, they're very used to it. Self-evidently, the judges have the appropriate skills and training. Self-evidently, there isn't some evaluative exercise which is more suited to the Secretary of State and on democratic grounds is more apt to be decided by the Secretary of State. So if we turn to the next slide, please. And so he was also, in giving the judgment of the court, motivated by the fact that on the question of fraud, that while the Secretary of State might make reasonable judgments on the materials available at the time that she made the decision, these could be shown to be wrong, that by further evidence adduced and tested in the adversarial context of an upper tribunal hearing. And there was nothing, as we already mentioned in Lord Reed's elaboration of the framework principles in Begum that prevented such a conclusion. And finally, just in a kind of wrapping up way on that point, just to note that although it wasn't at the centre of what was decided in Chowdhury, he agreed that it was for the Secretary of State to prove on the balance of probabilities that there was fraud. And so it's just something worth noting in passing, of course, because where fraud is alleged as opposed to an innocent mistake, the burden rests on the Secretary of State in this context, as in others. And then if we turn to the next slide, please. So now we come to the little sandwich bit about what happened. Is it where the fraud, where the question of whether the citizenship was obtained by the fraud, not whether the fraud existed. So obviously there is a little bit of hair splitting going on, but this was a point that the Secretary of State clawed back from her general acceptance that fraud could be looked at by the tribunal for itself. And if you remember, the Secretary of State said, well, on that question, on this question about whether the citizenship was obtained by fraud, that's only going to be reviewable on appeal on public law principles, so on Wednesbury grounds for practical purposes. And the Court of Appeal agreed with the Secretary of State on that, and the reason was, in the court's reasoning, was that this question about whether citizenship was obtained by means of fraud, according to the court, according to Lord Justice Dingemans, was that's a matter critically dependent on the Secretary of State's previous decision-making, which she's in a better position. So again, a question of institutional competence to make the primary evaluation. And you might think, well, what does all of that mean? Well, imagine if leave to enter or remain is obtained by means of deception and the Secretary of State's record keeping and evaluation of circumstances is in issue. That's her previous decision making, or imagine the factors that led to her finding out that there was some form of impersonation or some form of misrepresentation, deliberate misrepresentation, so it's dishonest. That's something which she has a certain competence to evaluate in terms of her internal processes. Now, for my own part, I'm not so sure about that reasoning and in the terms of how it supports this proposition. It may be that the tribunal is just as well placed as the Secretary of State to examine if, on full disclosure of the Secretary of State's decision-making process, and has the competence to uncover whether or not the citizenship was obtained by means of the fraud. And so this may not, and the consequences of that, if that's right, is that perhaps that too ought to be the subject of a fact-finding jurisdiction in the first tier tribunal. But for the moment, the Court of Appeal has spoken, and therefore its decision on this matter is binding, unless for some reason it can be shown that the judgment, it was not critical, or the reasoning on this part for the determination of the appeal. But it's certainly the Court of Appeal's view that this is to be judicially just looked at and examined in the small number of cases in which this point arises on judicial review principles only. And if I can have the next slide, please. And then finally, just to look at these issues sweeping up, and the third issue of the exercise of discretion is accepted that was only to be looked at on public law principles, not on a fact-finding basis. And then, of course, on human rights considerations, always coming in at the last for consideration after the statutory test has been considered in its various limbs. That it was obviously a matter for the tribunal to consider whether the Secretary of State's acted in breach, and that can do so on consideration of all relevant evidence, including new evidence. Although, of course, due weight will be given to the whatever that means, and that's always a bit of a movable feast, to the findings, evaluations, and policies of the Secretary of State. But in doing that, that was still a matter for the first tier tribunal. And so if I could have the next slide, please. And so there's going to need to be a revision of the tests as they're set out into Cherry and Chimmy in terms of evidence is now can be adduced on the precedent facts of fraud, as well as on matters that go to human rights, so new evidence that wasn't before the Secretary of State. That evidence can be examined in one go by the first tier tribunal, although there are separate legal tests. Is there fraud? Is there a violation of convention principles? On the facts of the case, Lord Justice Dingemans found that the first tier tribunal had failed to consider the Secretary of State's aspects of the Secretary of State's case. Therefore, the reasoning was inadequate and it was going to be sent back there. So in the result, they have to start at the foothills all over again, but in happier on a happier legal test, that fraud can be examined for itself. I think that's it.
I'll start with the facts really quickly. Okay, so this is an interesting case for a number of reasons. It emerged out of so just go back, if you don't mind, one slide. Yeah, thanks. It emerged from a gentleman, Mr. Kolokaj. He was a dual British-Albanian national, well established here, naturalised in 2009, married with a family of 4 British children. He pleaded guilty to a money laundering offence, which wasn't a particularly sophisticated money laundering offence, but was one that was treated as quite serious. He was involved with a group who was essentially exporting cash that was the product of criminal activity in the UK via flights to other European capitals to Albania in suitcases. So literally suitcases full of cash going back to Albania. And he was arrested, charged, and eventually pled guilty and received 6 years in custody. Where things got quite interesting was, in this case, the Secretary of State decided to serve a notice of intention to deprive him of his British citizenship under Section 40, subsection 2, so conducive to the public good, essentially at the same time as the deprivation order was served on him in prison. So I think it was about 30 minutes, according to the Court of Appeal, between the notice of intention and the signed deprivation order. Anybody with a modicum of experience in public law will immediately see there's a potential problem with that. And indeed, that's what the Court of Appeal found too. Could I have the next slide, please? What seemed to have happened is there were 2 new policies that organically had been developed by the Secretary of State shortly, or in the years before the deprivation order was made against Mr. Kolokaj. The first was that there was essentially an expansion of the conducive to the public good deprivation policy to take into the ambit many more serious organised crime cases than had historically been the case. So there was a civil servant wrote to the Secretary of State saying we should really be looking at deprivation orders in a wider group of cases where there's been serious organised crime, and the Section 40, subsection 2 power could be deployed. And that's really what triggered the action in Mr. Kolakaji's case. And the advice of the National Crime Agency to the Secretary of State was to pursue deprivation, and that's what they did. The second and most critical new policy or practice for this case was that there was a change in the way that the Secretary of State made the relationship between the notice of decision to make a deprivation order and the deprivation order itself. Historically, the practice had always been that the Secretary of State would first of all make a notice, or give the notice and the decision to deprive. There would be a right of appeal against that decision, and only after that appeal, and any appeal rights onward have been exhausted, would the actual deprivation order be made. But what happened was, during the Rochdale grooming cases, the aftermath of that, it was discovered that there was a potential loophole. So where somebody was served with a notice of deprivation, they could then, in certain circumstances, depending on the nationality, renounce their original citizenship, and therefore the deprivation order would potentially leave them stateless. So what appears to have happened is the Secretary of State has changed her policy in response to that, and then began to serve the notice and the deprivation order practically simultaneously, specifically to avoid the scenario where someone could essentially get out of the deprivation order by having no other nationality. Can I have the next slide, please? This was an absolute masterclass in how not to develop a new policy that could withstand a challenge. And it is scarcely believable the way they did this. But the first thing they did was they didn't write it down anywhere, according to the Court of Appeal. Paragraph 14 of the judgment says that this new practice and approach wasn't reduced to writing and wasn't recorded anywhere within the Home Office. And the second, and perhaps the two are related, the Court of Appeal noted that there didn't appear to be any consideration with regard to the implications for fairness of making the notice of intention and the deprivation order essentially at the same time. So the case reached the upper tribunal. The first tier tribunal, somewhat surprisingly, decided that the Secretary of State's position was fine. It reached the upper tribunal, and they made an interesting finding that, even taking into account the long line of authorities about procedural fairness, which says if the Secretary of State is minded to make a decision based on criminality, dishonesty, deception, or otherwise bad faith, what they're supposed to do is give the person an opportunity to meet the case against them before making the final decision. And obviously, if they're serving both the notice of intention and the final order together, you're missing out an important part of that procedural safeguard. There's no opportunity for the individual to make representations as to, firstly, what the effect of that order might be on his individual circumstances, and secondly, why it might otherwise be unlawful to make it. So the upper tribunal noted this, noted the line of authority, including Balajagari, but found that the risk of renunciation in these circumstances justified the potential unfairness and justified missing out the minded to process. Now, the Court of Appeal, in the course of their decision, took into account Begum and the limits of a first-tier tribunal appeal under Section 42, and considered that, no, it was fundamentally unfair to have a procedure where at no stage could the affected party make representations as to why the decision should not take its course. What the Court of Appeal said was that it might well be lawful to avoid the risk of someone renouncing their original nationality. It might well be lawful to make the decision simultaneously with the indication that one was going to be made. However, what was absolutely necessary for fairness was that there was some sort of procedure where there would be a complete merits review by the Secretary of State once the order had been served, essentially allowing for any material that hadn't been taken into account to be taken into account. And so they struck down the upper tribunal's decision on that ground. Can I have the next slide, please? Just before I move on to Latchi, Collicage also had two other issues in it. One had to do with whether or not the policy with regard to widening the scope of Section 42 decisions at the time was effectively an unpublished policy and therefore bad in public law terms. That didn't really go anywhere because of their other findings. The upper tribunal also found that the Secretary of State hadn't appreciated when she signed the order that she had in fact had a discretion whether to sign the order or not. The upper tribunal said that they would have allowed the Secretary of State's appeal on that basis, but the procedural fairness point essentially overtook all of that and rendered.
Gordon, I think you might have frozen, but possibly at almost the end of your presentation, although I think we were just talking about the upper tribunal rather than maybe before the appeal. And Gordon was also just going to come on to talk about his case of Latchi, which was dismissed on the facts. It was heard before this trio of cases, and before the Secretary of State made her welcome concession that she did in Chowdhury, that in fact the tribunal could undertake fact finding. So it was superseded by those cases. But I don't know. If, Gordon, you are back. Do you want to say anything about that before?
I'll leave whilst the going is good. Basically, yeah, Latchi hopefully of historical interest only. Upper Tribunal taking a different view to the three cases in the Court of Appeal before they were promulgated, and so therefore permission is likely, one would have thought, to be granted to appeal to the Court of Appeal, or the case otherwise set aside. But yeah, look, thanks very much. I'm sorry for the difficulties, and thank you for bearing with me.
Thanks very much, Gordon. I would have thought, just thinking about your case of Latchi, that if the Secretary of State changed her position, that even in a non-cost-based jurisdiction in the upper tribunal, that you could, in fact, get your costs, because they really have changed, did a volte-face on the fact-finding role.
Yeah.
So, thank you very much. So I'm going to talk about the case that I did, which was the third of the three cases that were in the trio that we've been talking about. So the first in time was Chowdhury, the second in time was Collicaj, and then the third one was Dachi. And the case was heard by, so all three cases were heard by the same panel in the Court of Appeal, although interestingly not conducted by the same counsel. So Chowdhury was conducted for the Secretary of State by David Blundell and Julia Smythe and Harriet Wakeman, I think, and then the case of Collicaj was conducted by Catherine McGarhy, and then the case of Dachi by Julia Smythe and Harriet Wakeman. So there was some commonality and some difference, and they didn't all advance the cases in exactly the same way, save for the very clear concession on the fact-finding point, which didn't arise in Dachi per se. Sorry, can I go to the first slide? Thank you. So the issues in the case of Dachi were whether the upper tribunal had erred in finding that the Secretary of State's decision to deprive on the basis of his British citizenship on the basis of his admitted fraud was unlawful. And the Secretary of State, the upper tribunal had found that the Secretary of State had failed in the decision letter to give proper reasons for her decision. The Secretary of State said that there had been some errors, but argued that they weren't material. And the court found that applying a public law test of rationality and proportion and proportionality at common law, interestingly, that the Secretary of State had properly exercised her discretion and provided adequate reason. There was the respondent, Mr. Dachi, filed a respondent's notice to argue that the upper tribunal had in fact erred in law in failing to determine the Article 8 ground appeal that was before them. Now, this was slightly problematic in the sense that the parties below, I didn't represent below, had said that the court should apply Chini, which was of course the reported decision from the upper tribunal at the time, which is that if the appeal was successful on public law grounds, and the upper tribunal didn't need to determine the Article 8 appeal, even where they had heard evidence on it and had heard submissions on it. And in short, the Secretary of State's position was that it might be good practice to determine an Article 8 appeal, but it wasn't an error of law not to. And in fact, what happened here, and there's a comma there, the Court of Appeal noted in the judgment in Dachi that it was agreed between the parties that the claim, the Article 8 appeal, should be remitted to the upper tribunal. Next slide, please. So, what I'm really saying is that the court, as I'll come on to mention, didn't grapple with whether Chini was wrongly decided, but I'll come back to that in a moment. So just in order to contextualise what those findings mean, the facts are that Mr. Dachi entered the UK when he was 17 years old. So he came as a child, and he claimed asylum as a child, and he provided a false name, date of birth, and nationality. And 2 months after his 18th birthday, he was granted leave to remain as a refugee. So importantly for his purposes, he hadn't taken any active step between his application for asylum and the grant of leave as a refugee. And later on, he applied for a Home Office travel document in that false identity, applied to naturalise as a British citizen, and he signed the declaration confirming the information was correct. And so he became a British citizen under a false name. Some over a decade or so later, Mr. Dachi's correct identity became known to the Home Office, and that's where the action started to take place in terms of deprivation. So unlike some of the other cases that we've just been discussing here, like Mr. Kolikai, which again was reminding that was a 42 appeal, not a 43 appeal, i.e. this one was on grounds of fraud only, the Secretary of State informed the Mr. Dachi that consideration was being given to depriving him of his citizenship. And he made representations to the Secretary of State, including on the basis that he'd been a minor when he entered and he couldn't be regarded as complicit in the deception, and also argued about the impact of delay. So the court, and then the Secretary of State's policy determines complicity by age, and says if the deception was at the time when the person was a child, they wouldn't be regarded as complicit. And the representations Mr. Dachi made were that there was no intervening act between the claim and the grant, and therefore he wasn't complicit. And really what had happened was that there was an absence of action at best from him whilst he was a child, and he was a child in care, and then a child who was under the leave in care provisions of the local authority. The Secretary of State still took the decision to deprive Mr. Dachi of his citizenship on the basis it had been obtained by fraud, and did not and rejected the argument that although he had acquired, although the initial fraud was when he was a minor, that he'd maintained the fraud over 20 years and he'd acquired the indefinite leave to remain as an adult. And that in any event, and this is the Secretary of State's point that she pushes home in many cases that you will have seen, had he told the truth, his citizenship application would have been refused on good character grounds. And moreover, and this is going back to the earlier Court of Appeal case in Lachi, which some of you will be familiar with, there wasn't in this case on the facts any delay in dealing with his claim once the fraud had come to light. Can we just go to the next slide, please? In this case, unlike in Chowdhury and in Kolikai, there was no factual dispute. So there wasn't any findings of fact to be made by the tribunal in relation to the examination of the Secretary of State's decision on the public law grounds, so to speak, or the deprivation principle. So ultimately the public law principles applied to this appeal, that's issues 1, 2, and 3 that Lord Justice Dingerman set out in the case of Chowdhury, which Adrian has just taken you to, which is for the tribunal to decide the question of if there's a dispute of fact, but then the decision of the Secretary of State on the causation question is on public law grounds, and then the exercise of the Secretary of State's discretion is also then to be reviewed on public law grounds, and then finally and only it's the question of the Article 8 appeal where the tribunal has to reach a decision for itself, and we'll come back to that in a moment. In Mr. Daci's case, the first tier had allowed his appeal, but that was set aside by the Upper Tribunal, who remade it. And they also allowed the appeal, but for different reasons. And the Upper Tribunal said, on allowing the appeal, that it couldn't be said that the discretion had been lawfully exercised, having regard to the variety of factors before the decision maker, that the outcome would inevitably be negative for Mr. Daci, with reference really a nod to the fact that about his age, because that was the one might be said to be compelling or factor that drew him apart from other similar cases. And as I mentioned, they remitted the decision to the Secretary of State to remake. They, of course, observed if that decision was negative, there would be a further right of appeal, but they didn't go on to determine the Article 8 claim. That's exactly aligned with the Chimmy approach. Next slide. So, is Chimmy wrongly decided? Well, the Court of Appeal didn't go that far. In fact, they didn't actually determine that question, because it was agreed, of course, that the case had to be remitted in respect of Article 8 in any event. So rather frustratingly, even though we'd argued that there was a Chimmy error, or rather that Chimmy was erroneously decided, that the court didn't just determine that question. So in order to advise people in practical terms what to do going forwards, my view would be very clearly that parties and the tribunal would be well advised to call evidence, hear evidence, determine that issue, invite the appeal to be determined if you are the party, whatever the outcome of the public law grounds are. Otherwise, you'll be stuck in the position that Mr. Daci was, where everybody said they needed to go back, but he won his appeal and he was defending the decision of the Upper Tribunal on public law grounds. In my view, it's still arguable that there is a right of appeal under the statutory framework, and that because the tribunal has an appeal before it, it should determine all of those grounds, and that is also consistent with the overriding objective. So that, to my mind, is really how we should be putting the point. If you're in a statutory appeal where you've got the public law limb and the Article 8 limb, whether or not you've got a dispute of fact. And then, obviously, what are we going to do when the appeal comes back before the Upper Tribunal? So, importantly, we do need to try to hone and fashion of what those Article 8 grounds might look like. Again, just reminding you all, I'm sure you are familiar with, or many of you are, that following Aziz, which was, of course, a Section 42 case, that there should be no proleptic analysis, according to Lord Justice Sayles, as he was, in terms of it's the impact of deprivation, not deportation or removal, that the court is concerned with examining. However, within, of course, the Article 8 framework, the tribunal has to look at whether the decision to deprive is in accordance with the law, and that includes the relevant impact on children in relation to Section 55. So what are the impact of this person being deprived, and whether they are then rendered without any immigration status. So according to the Secretary of State, they don't revert to indefinite leave to remain on deprivation. There's an argument still to be had about that. And then the limbo period, and that is really how many cases have been presented, which is if the Secretary of State is going to take a significant period of time to determine the question of whether she's going to remove you, grant you, or deport, then grant leave, then that leaves the person, if they don't revert to any of their previous status, in a limbo without any leave. And if, depending on what your factual matrix is, and many of the cases that I've come across have been people, whether there's a husband who's working, a wife who isn't working, children who are being supported by the father through his earnings, employees who are employed through the individual, and all of those are relevant considerations to the question of the proportionality of the Article 8 when the tribunal were examining it. And it's the second part of that is also whether there's a consistency in the application of policy to determine whether there has been a lawful and proportionate approach. And length of residence is a factor under the policy, although it's no longer the 14-year sort of policy as was, which where previously until about 2013, 2014, I think it was, Secretary of State said, oh, if you've been here for more than 14 years, she wouldn't ordinarily deprive. It still is a relevant factor, and that is written into the policy. So if that's not properly considered, then it needs to be looked at. Is the decision arbitrary in the Usmanov context? That's the Strasbourg case. So if you can show evidence of other people who have been treated differently, and I think there is a body of some, quite difficult to try to gather this evidence, but I was looking back at the Chief Inspector's report from 2023, and actually there's quite a significant number of cases that have been allowed on an Article 8 basis. And it may be useful to try and do a little bit of research or gather statistics. If your client has a friend or a relative who has been treated differently, then you've got the building blocks potentially for an argument in relation to arbitrariness. And again, if there's an argument that the Secretary of State knew about the deprivation, knew about the fraud, for example, through an earlier entry clearance application and so on, then again, you may find that there's a basis for demonstrating that it's arbitrary to now deprive somebody after so many years. But one of the arguments, and these are going to have to be tested in going forward, is if the person is unlikely to, this again, if you have children, if the individual is unlikely to be able to reacquire their British citizenship for a minimum of, say, 11 years, so you've got somebody who's going to be deprived, they have no status, then they may be within, it could be a month, it could be 6 months, it could be 12 months, they get a new decision to grant them limited leave on a rolling basis of 30 months to a 10-year, on a 10-year route. Then after 10 years, they may or may not get their indefinite leave to remain. And if they do, they may then be, after another further year, be able to apply for their citizenship again. But at the moment, there's a very strong question mark as to whether they would be able to reacquire or to be granted naturalisation in the future. Even looking at the Secretary of State's policy considerations on good character and when she will, at what stage passage of time she might decide to not to overlook or to conclude it's disproportionate. So you will have somebody like in the case of Mr. Dachi, who's been in the UK since he was 17, and in fact, so he came in 1998. So he will have been here 30 or 40 years by the time before he can reapply for British citizenship. And actually, when coming back to looking at his original fraud at the age of 17, it might well be said, in his case, that it is disproportionate to deprive him in the context of where and when he might be even eligible to apply, let alone whether in fact he would be granted citizenship. So all of those are factors that will need to be considered by the tribunal. And it was interesting that Lord Justice Dingemans, in the judgment, when he was looking at the question of the exercise of discretion, saying, well, the Secretary of State gave sufficient reasons in her decision letter, and that applied the policy correctly. He concluded that there was that the decision was lawful, rational, and proportionate at common law. So a case like this might well exemplify where that boundary is to be struck between proportionality under common law and the Article 8 proportionality question that ordinarily follows in the human rights claim. Even where any immigration judge deciding that question would have to would have to give weight to the Secretary of State's findings, evaluation and policy. So there still is on certain cases with particular facts, there is still a window of opportunity for cases to be won or successful on that basis. You have to work quite hard to build up the evidential and legal picture. And in fact, what I read from the Chief Inspector's report was that there were, in fact, quite a number of cases that had been allowed under Article 8. So, in a way, all is not lost. So, thank you very much. I hope you could all hear me. And apologies for the technical difficulties. One of the questions is it proportionate for the Secretary of State to propose the family return to the country of the other nationality? Well, I think that, I would hope that that is not the kind of response that you can get from the Secretary of State in a deprivation appeal, which isn't considering shouldn't be considering where people are going to live, that should be considering what is the limited impact of deprivation of nationality now, before any decision to remove or deport or grant leave has been taken. So I wouldn't expect to, or we shouldn't be expecting to see positions adopted by the Secretary of State in that manner. So there's a question, it's encouraging to hear that you still think there's an argument to be had on the question of someone reverting to ILR in the event of deprivation. It's easy to conceive of a situation where ILR was obtained without any issues of fraud, and that the fraud only related to citizenship. In that scenario, you end up being in a worse position than if you'd stuck to ILR. Why should you lose the foundations when they were solid because of a subsequent fraudulent event? Are you able to shed any light on how you think this debate may develop? Well, it's interesting, isn't it? Because in fact, on the facts of Dachi, as I've just outlined them, he acquired his ILR, aside from not telling the Secretary of State immediately that he turned 18, that he was actually from a different nationality. He acquired his ILR without doing anything more. Now, the argument about the citizenship has been lost so far, but in relation to, and in fact, Secretary of State's point was, well, you carried on, you perpetuated the fraud and you applied for citizenship in a false name and you knew about that and everything else. But in terms of the acquisition of ILR, he was 18 and 2 months when he acquired ILR, and actually his culpability or complicity in the acquisition of ILR rather different than that in respect of his citizenship. But there's a more fundamental point, as you think of alluding to there, which is that the argument about reverting to ILR on deprivation has so far been lost, but only at the tribunal level. That's in High Judge number 3. I don't think there's a higher court decision yet on that. And I still maintain that, unlike the position of the Secretary of State in High Judge number 3, that on the grant of British citizenship, your ILR vanishes into the ether, and I quote, that was the Secretary of State's submission from their silk, not from presenting officer. But I think it was Robert Palmer, I can't remember now. So there is an argument, I still think, that which requires some determination. Not to say that that ILR can't be revoked, but for some people who've acquired it as a child or acquired it in the circumstances that I've just outlined for Mr. Dachi, potentially there is an argument about that, and maybe for other persons as well. So, but if you, I mean, it is right to say if you do revert to ILR, then there's no limbo. So that would, it would undermine an Article 8 claim in a different way. But it's important to know what your status is as a matter of law on deprivation of citizenship. So I think that, you know, there's still maybe some argument there. I had understood, just coming back to the point about notice and about what your status is on deprivation, that the Secretary of State and the limbo period, that the Secretary of State is now trying to make those decisions more quickly, and not 6 to 8 weeks, but then suggesting 4 weeks. But I think we still need to look at the statistical analysis of what averagely the waiting time people are in fact having to wait. So that's another part of that sort of Article 8 jigsaw puzzle on. I can't see any other questions. I'm very happy, Adrian or Gordon, if you want to say anything closing, any thoughts you've had on what you've heard or what I've said.
I don't really have anything to add. I do think the question of ILR reviving is quite a complicated one, because of ILR's sort of function, really, not so much as a status as a description of the last occasion on which you were given permission to be here. But you can see examples actually in the old immigration European Economic Area regulations of 2016. This isn't a Brexit nostalgia story, but when you had limited leave and then you got an EU right to reside, there was a bit in one of the schedules which said your conditions of your leave do not apply for so long as you enjoy a right to reside. The implication being that if the right lapsed, the leave continued to subsist, which is a little bit of a hint that rights may not obliterate or annihilate leave to enter or remain if it continues to subsist. But whether that was just speaking as a description of the law or changing the law in respect of underlying leave to enter or remain is a moot point.
Yeah, just on that, I was in a case quite a long time ago now, I think about 10 years ago, called Fitzroy George, which ended up in the Supreme Court about what happens to your ILR if your deportation order was revoked under the old system. And the Supreme Court said that, well, it's gone. So the ILR doesn't survive the deportation order, even if that deportation order has been revoked. So I suspect there might be some shared logic between the two jurisdictions on that point.
Yes, I think that's how, I think it was reliance on Fitzroy George that the tribunal used in hindsight number 3, but I still say that those, although there's there's a logic that's there, but if when evaluated against the respective statutory schemes, it's very different. And the construction argument, I think, doesn't necessarily carry over from the 1971 Act in that way, and those deportation orders to the revocation, to the ILR and revocation, particularly because if ILR is acquired by fraud and everything else, that it can be revoked, and that's the remedy for the Secretary of State if she wants to use it. Everybody, thank you very much for coming. So thank you very much to Gordon. Sorry that you had such difficulty with your internet provider. And thank you to Adrian Berry.